Good afternoon. Welcome to Long Live Third Parties Podcast. Free Press Media Press, Inc., a third parties bookstore, sponsors this podcast. I'm Andrew Bouchard. Today I read the case, Matter of Stoppenbach v. Sweeney, 778 NE2D 1040, New York Court of Appeals, 2002. Friends, today we have a short and sweet case. This short and sweet case can illustrate principles, it can illuminate insight, and it can inspire us. This case involves the Independence Party. Since it's in New York, I don't believe it's the same Independence Party that won the Minnesota State Governorship in 1998. You can correct me if I'm wrong, but that's the way I'm reading it. I believe this is another party altogether. I do not believe they're affiliated with that Minnesota Victorious Party. So what happened in this case? Let's read from the record. It says, quote, Objector commenced this proceeding challenging the sufficiency of the petition designating John Sweeney as the Independence Party candidate for the House of Representatives for the 20th Congressional District. Supreme Court invalidated the petition, excluding 48 signatures for failure of the signers to accurately designate a town or city, leaving an insufficient number of valid signatures. See Election Law 6-130, 6-136. The Appellate Division affirmed with 2 judges dissenting. End quote. I would love to see that dissent of those judges. I do not believe I found a similar appeals case when I found this case. It would be interesting to find out the grounds for their dissent and how they articulated the third party point of view. Or at least they undermine the other point of view, because a dissent could be in many directions. The objector sucks because he's objecting to what we need to happen. We need our friends on the ballot. So friends, let us think about this. This case is almost 1 page long. It is slightly over 1 page. It's barely a paragraph on the second page. What they do is they discuss a couple of cases about the town name. They mention one case we discussed in a prior podcast, Zoll versus New York State Board of Elections, and then also this other one from 1982. Since we focus on cases 1990 and above, I don't plan on reading that one, the one from 1982. And they discuss another case which is an unpublished case, and we avoid unpublished cases. So ultimately, they concluded the signatures were valid, or invalid, rightfully, according to them at least, and therefore our friends at the Independence Party of New York did not get to be on the ballot. We did get a consolation prize, so let me read their conclusion. It says, quote, Accordingly, the order of the Appellate Division should be affirmed without cost. Objectors' cross appeals should be dismissed for lack of agreement. On appeal by appellant, respondent, order affirmed without cost. Appeal by respondent, appellant dismissed without cost for lack of agreement. End quote. You hear that lack of agreement? That's what we want to hear. So friends, although we didn't win, we got a consolation prize that the objector fool didn't get their way. So friends, let us find inspiration in this and let us use this to inspire ourselves and others. Long live third parties. Goodbye.